Hi, I'm Derek Fahey, a registered patent attorney and trademark attorney with the Plus IP firm, and this is going to be a brief video on how long patents last for. So as I mentioned, I'm a registered patent attorney. I have a background in engineering, and I took a separate bar exam to become a patent attorney. If you're looking for a patent attorney, make sure they actually took and passed a patent bar. Very important. Now, let's go back to the topic. I want to talk about how long a patent lasts for. So a patent actually does not last forever. And how long a patent's term is depends on what type of patent it is. So there's three types of patents. There is a planned patent, there is a design patent, and there is a utility patent. And each type of patent lasts for a certain length of time. It has different things. So for example, let's talk about what a planned patent is. A planned patent is a new and distinct variety that is asexually reproduced. So a planned patent lasts for 20 years from the filing date of the patent application. Let me back up. To get a patent, you actually have to file a patent application with the patent office. It has to be examined, it has to meet the requirements of the US government, and then it has to issue. So a patent, a planned patent, lasts for 20 years after the filing date of the planned patent application. So if it's filed in December 31st, 2020, and it issues in January 2022, you have to count 20 years from December 31st, 2020. That's when the patent expires. After 20 years, everybody can actually benefit from the information that's in the patent. That's the planned patent, so 20 years from the filing date. A utility patent is also 20 years from the filing date of the application. So for example, in certain cases, utility patents actually can benefit from a previously filed patent application. In those cases, you have to be careful, because if the utility patent claims the benefit of a previously filed non-provisional patent application, then the patent term would be 20 years from the first filed non-provisional patent application. So you'd calculate from the first filed non-provisional patent application 20 years from that date, not the date of issue. So on the actual application, on the patent itself, it actually will say the date of the patent and also when the patent application was filed, and if there's any other filing dates or any other patent applications that were filed as well. So when you look at a patent, you need to look at, for utility patent applications, if there's any other patent applications that it's claiming the benefit to. It's very important to look at if there are any other applications that the patent is claiming the filing date. It's called a priority date. Really important. You need to take a look at that. Interestingly, in the US, we have what's called provisional patent applications. Provisional patent applications never actually mature into a utility patent. You have to actually file a non-provisional. So even though you benefit from the filing date of the provisional, the measurement of when the patent term will be from is actually, they don't count the provisional patent application. Here is the situation. You file a provisional patent application this year. Next year you file the non-provisional patent application, and then the patent issues. 20 years from the date of the non-provisional, the patent will expire, not the provisional. You get the benefit of the early filing date of the provisional, but the patent term actually extends from the 20 years from the non-provisional filing date. It's actually a benefit. People say it's a patent term, you're extending the term of the patent by 1 year. So essentially you measure it from the date of the non-provisional patent application when it was filed. Design patent applications are a bit different. Design patents last 15 years from the date the patent issues. So unlike utility patents and planned patents that last for 20 years from the filing date, design patents last 15 years from the date the patent issues. It's a bit different. So planned patents and utility patents, planned and utility last 20 years from the filing date of the applications, whereas design patents last 15 years from the date of the patent issues. So when you look at the patent document, you need to pay close attention to those. If you have any questions about how long the patent lasts for or the patent term actually is, please give us a call. We're happy to help. Our website is www.plusfirm.com. You can find me on Instagram, Derek Fahey PA. I'm also on TikTok under the same name, Derek Fahey PA. We're happy to help and answer any questions you have. If you want to leave some questions in the comment section on the video, please feel free. We're looking forward to helping you and helping you make your patent application be granted, or also evaluate whether or not your patent there's a patent that could be an issue for you. So looking forward to hearing from you. Have a wonderful day. Talk soon.